that this assault did not occur. She also stated, please do not arrest me. I don't know why somebody would say, please do not arrest me when they were the victim of an assault. So under no circumstance, honestly and truly, this is not a close call for me. There's no way the prosecutor proved her case beyond a reasonable doubt. You did a really good job, Ms. White.
Judge, I appreciate it.
And Ms. Holloway, you are going to be one remarkable lawyer. You've only been practicing how long?
Almost 5 years.
Well, you are going to be a really good lawyer. I love your demeanor, and I think you are going to be judge material. I find the defendant not guilty, and again, this is not really a close call. So
Judge, we appreciate
you're
it.
discharged,
Thank you,
and
Your Honor.
thank you.
Rule 6.419 AC, looking at a light most favorable to the prosecution without weighing the credibility of the witnesses, it is our position that the trier of fact cannot find that all of the essential elements of the offense of domestic violence have been proven beyond a reasonable doubt. Mr. Kennard is charged with domestic violence contrary to MCL 780.81 subsection 2. Number 1, pursuant to the criminal jury instructions, the people would have to prove that Mr. Kennard assaulted Miss Bonnie Stewart. Number 2, that Mr. Kennard is her spouse. Pursuant to the criminal jury instructions 17.2A, the essential elements would be, number 1, a battery is a forceful.
The defense just dropped a massive bombshell, claiming a complete lack of physical injuries. But as the prosecution steps up to respond, the entire momentum of this trial is about to hinge on a single, unexpected description.
Recording that the complainant objected to on the witness stand, he says, Bonnie, you have twice lunged at me trying to grab my phone and screamed, I hit you. She replies on the audio video recording, no. He's telling her to get away from him at least 24 times, both before and after any alleged assault. She threatened him, and if the court remembers, in a very calm voice, she says, I'll call the cops. He tells her point blank on the recording, I did not hit you. On the video recording, you can see he's still in the bed and she's still standing at the foot of the bed, insisting that he either communicate with her or provide him with his phone. And this takes place after the alleged assault. The second witness, Sergeant Canterbury, testified as a sergeant and a supervisor that he completes detailed written reports. The complaining witness claimed that, according to Sergeant Canterbury on the scene, that Mr. Kennard struck her one time on her right forearm. The forearm, he testified, is the lower portion of the arm. The complaining witness testified on direct examination when either the court or the prosecutor questioned her regarding the positioning on the arm or the portion of the arm where he's alleged to have hit her. She testified the upper area of the arm or the tricep. Lastly, Your Honor, the defense admitted Exhibit 2, Sergeant Canterbury's body-worn camera. After the fact, she asked Sergeant, please don't arrest me. After the fact, when the police are on the scene, she doesn't cry or become hysterical until her husband is being arrested for a crime that he did not commit. Thank you, Judge, for listening.
Any response?
Yes, Your Honor. Your Honor, when considering the motion for the directed verdict, the court must consider the evidence in the light most favorable to the prosecution. Now, defense counsel did just lay out the elements for domestic violence. So in this case, we do have to prove that an assault and or an assault battery occurred under the statute. And the prosecution did not need to prove injury in this case, and although we did not see any photos of injury, we did hear testimony about an injury. In addition, we heard testimony that the complainant was terrified of the defendant, Stephen Kennard, and he also saw body cam and police Sergeant Canterbury's testimony that he observed Miss Stewart afraid and blinking and darting her eyes, indicating that she didn't want to be heard around Stephen Kennard. Again, under the statute, we need to prove an assault and or an assault and battery. And whether
You know what? I thank you very much. Taking all the evidence, like most favorable to the prosecution, the court finds that a reasonable fact finder could find proof beyond a reasonable doubt. There is still testimony as to whether or not the defendant battered the victim. There was testimony from the victim that she was struck in the arm. There is a dispute, obviously, with regard to where that would have occurred. I acknowledge that there were no injuries. However, an assault and battery does not require an injury, so I'm going to deny the defense's.
Officers on the scene strategically separated a 3-year-old child to find the absolute truth. And what this toddler voluntarily reveals to the police changes the entire narrative of who the real victim is.
Her desire was regarding the arrest of her husband.
I don't recall if she specifically said something to me. I'm sure she did say something to my sergeant.
Okay,
Sergeant.
and with reviewing your body worn camera that has been admitted into evidence, refresh your recollection.
Yes.
Oh, thank
By the way, I record all these. I didn't this morning, but I told them to go on, so you're on YouTube for whatever it's worth.
Okay, thank you. Thank you. May I approach the witness again?
May.
Thank you. Or you know what, the microphone is here, so, well, I don't know. I'm gonna play 7 minutes at the 7-minute and 32-second mark.
Right now.
Slow down. Can you turn that up a little bit, please?
Sure. I think I'll do what the prosecutor did and stand by the microphone.
That's fine.
Okay, thank you.
you took the microphone to the speaker,
Like this?
just bend it towards your iPad.
Oh, so sorry. Thank you. Did you hear her say that on your body worn camera?
Yes.
Did you hear her say, I don't want him gone, I don't want him arrested?
Yes.
Does that refresh your recollection, sir?
Yes.
Oh, okay. Now, did you have contact with another individual that was inside of the location?
Yes.
And who would that be?
It would be the son.
Okay, and do you recall the son's name?
At this time, no.
And if I suggested Stewart, does
Yes.
that, it is Stewart, okay. And how old is Stewart, if you recall?
That I do not remember.
If I suggest to you that he's 3 years old, would you?
Maybe I don't remember asking, but I may have.
Okay, no problem. And can we agree that you had communication with Stewart, is that right?
Yes.
And do you recall, Stewart making any volunteering any statements to you?
Yes.
Okay, and in fact, what did Stewart say to you when he volunteered?
Right before we were going outside.
Yes.
To go play with them. He said that mommy hit daddy in the face.
Okay, I'm gonna play something for you. Very briefly, from our perspective, Judge.
Okay. Raise your right.
After months of complete and total silence, the defendant finally decides to take the witness stand under oath. What he is about to reveal next, including shocking photographic evidence, will catch the prosecutor and the entire courtroom completely off guard.
And heard the evidence in this particular trial.
Yes, I have.
Did you hit your wife?
No, I did not.
Did your wife hit you?
Yes, she did.
Judge, may I approach
Yes.
the witness? I'm sure, you know, before I am approaching you with defendant's proposed exhibit number 4. 4, 5, 6, and 7. Defendant's, can you identify what you see in defendant's proposed exhibit number 4?
That is my right bicep.
Okay, and do you see anything on your right bicep?
There's several bruises.
Okay, and when was, well, can you describe for the court what you're wearing, that shirt that you have on there?
That's the shirt that I had on when I was arrested.
Okay, and when was this photograph taken?
That was immediately after I was released, after the civil stand. Now I retrieved my belongings from my home.
And this photograph is taken inside of your home?
That photograph was taken at my mother's house.
At your mother's house, okay. And defense moves for the admission of defendant's exhibit number 4.
Your Honor, I'm gonna object. We have no way to authenticate this photo. It doesn't have a date, it doesn't have a time. We are solely relying on his testimony that it happened immediately.
That's subject to cross-examination. It accurately reflects how your bicep looked when you were released.
Yes, sir.
Defense 4 is admitted.
I am showing you what is marked as defendant's proposed exhibit number 5. Can you identify that photograph, sir?
That is my right hand, my index finger, on the inside of my knuckle.
And what do you see on that photo?
That's a cut on my inside of on my finger.
Was that photograph taken at the very same time that defendant's 4 was taken?
That's the very same time, yes.
Move for the admission, judge.
Any objection?
I'm gonna restate my single objection.
Does that accurately depict an injury that you received when your
Yes, sir.
wife assaulted you allegedly?
Yes, sir.
Defense 5 is admitted.
Thank you, judge. I am showing you defendant's proposed exhibit number 6. Can you identify that photograph, please?
That's the first photograph you showed me?
Nope, I'm sorry.
Yes.
Is that a closer up
That's a
photograph?
closer up, yes.
Okay, and does that accurately reflect your arm on the date and time that your wife allegedly assaulted you, sir?
Yes, it does.
Move for the admission, judge.
Same objection? Defense 6 is admitted.
Thank you, sir. Nothing further.
Cross?
Yes, sir. We have this. Sure, you have a minute. Well, that's okay. When I get out.
Okay.
So you were with Bonnie Stewart on April 3rd, 2026, is that right?
Correct.
And that day you had some kind of argument, not only with Bonnie Stewart, but with your ex-lady president in Ashley.
Correct.
And it was something about the custody of the children you have with Ashley. And so around that time, you were pretty frustrated about this argument that you had with Ashley, right?
Correct.
And following that, you then began arguing with Bonnie Stewart, is that right?
Correct.
There was a point in time, if you have heard from the testimony today, following this argument, you went upstairs to your bedroom, right?
Yes.
And you have a son with Bonnie Stewart, and is that right?
Yes.
And at some point, he came to your room with some kind of ice cream sandwich.
Yes.
And you were frustrated and you kind of dismissed it, right?
Yes.
And Bonnie then went to talk to you about that, is that right?
Yes.
So,
Judge, I'm just gonna place my objection on record and then I'm gonna sit down. It is outside the scope of direct.
Yeah, it's cross.
I.
Overruled. It's overruled.
Now, you indicated to your counsel that, you were injured from that day, right?
Correct.
Now, when the police first arrive,